5 seconds to go. Start. All the respondents accused were the members or office bearers of the said organization at the relevant time. As alleged in the charge sheet, though the PFI was projecting itself as an organization fighting for the rights of minorities, Dalits, and marginalized communities, it was pursuing a covert agenda to radicalize particular section of the society and to work towards undermining the concept of democracy and integrity of India. The investigation disclosed that the activities and undeclared objectives of PFI had strong communal and anti-national agenda to establish an Islamic rule in India by radicalization of Muslims and communalization of issues. After recruitment as members of PFI, they were motivated towards violent terrorist activities by providing training through beginners course and advanced training courses. During the training courses, physical education classes were conducted in which members were taught to attack, assault, maim, and murder with bare hands. The training was also given as to how to use weapons like knives and swords and how to hurl bombs. It appears that within few days of the arrest of the respondents on 22nd September 2022, the PFI was declared as an unlawful association and was banned by the Government of India under the UPA. We need not elaborate on the allegations made by the protected listed witnesses stating the role and involvement of each of the respondents who were either members or the office bearers of the PFI. Suffice it to say that there is sufficient material in the form of statements of witnesses and other incriminating evidence in the form of digital devices, books, photographs, etc., collected during the course of investigation and relied upon by the appellant as recorded in the charge sheet to form an opinion that there are reasonable grounds for believing that the accusations against the respondents accused are prima facie true. As stated in Vatali's case, the material evidence collated by the investigating agency in reference to the accusation against each of the accused concerned in the charge sheet would prevail until rebutted, contradicted, and overcome or disproved by other evidence. The material collated and statements of witnesses recorded also show prima facie complicity of the respondents accused in the commission of the alleged offences, which material evidence is good and sufficient on its face to establish the facts constituting the alleged offences till such material evidence is rebutted or contradicted. The court, at the stage of considering the bail applications of the respondents accused, is merely required to record a finding on the basis of broad probabilities regarding the inconvenience of the respondents in the commission of the alleged offences. In our opinion, the High Court has committed gross error in not considering the material evidence in its right and proper perspective and in recording a perverse finding to the effect that there was no material to suggest the commission of any offence which falls under section 15 of UPA and that the prosecution had not produced any material about the involvement of any of the respondents accused in any terrorist act or as a member of a terrorist gang or organization or training terrorism. Such perverse findings of the High Court deserve to be strongly deprecated, more particularly when the appellant has not alleged the offence under section 15 of UPA either in the FIR or in the charge sheet against the respondents. The alleged offences are under section 18, 18A, 18B, etc. For the purpose of considering the offence under section 18, the Commission of Terrorist Act as contemplated in section 15 of UPA is not required to be made out. What section 18 contemplates is that whoever conspires or attempts to commit or advocates, abets, advises, or incites, directly or knowingly facilitates the commission of a terrorist act or any act preparatory to the commission of a terrorist act would be punishable under the said provision. Stop.